ABCs of the UCCs. Article 8 and 9. Investment securities and secure transactions, respectively. Notes from the book. Taken by A.G. Middleditch on YouTube. Whenever securities were traded, whether in person or by phone, the settlement of the trade required that physical certificates be delivered from the seller to the purchaser. Also, when the securities were in registered form, as opposed to bearer form, discussed below, the certificates often had to be endorsed, or accompanied by an executed stock or bond power, or registered in the purchaser's name on the issuer's books. This focus on the physical transfer of certificates was, and remains today, a highly labor-intensive and complicated process. But the first completed versions of Article 8, approved in the 1950s and not widely enacted, recognized the concept of constructive delivery of securities held in street name by brokers. And the 1962 version of Article 8, prompted by a variety of non-uniform amendments proposed by New York, included provisions for the transfer and pledge of securities held within a central depository system or clearing corporation. With these steps, the importance of physical transfer began to diminish, and the concept of indirect holding began to emerge. Article 8 sought to reduce the systemic burden of transferring physical certificates by recognizing the role of multiple intermediary relationships, as either version had not, and also by providing for a system in which issuers would no longer need to issue certificates at all. Instead, a system of dematerialization was invented, under which ownership of uncertificated securities would be reflected merely by an entry in the records of the issuer in favor of the owner and not by any piece of paper. Transfers of securities, whether certificated or uncertificated, could be accomplished by transaction confirmations and book entries by intermediaries, instead of by physical delivery. An extensive pattern of security immobilization and indirect holding has developed. Under this pattern, physical certificates are still issued but tend not to be in the hands of the ultimate beneficial owners. Instead, they are mobilized with a clearing corporation and registered in the name of the clearing corporation, or, for administrative reasons, the clearing corporation's nominee. The clearing corporation for most publicly traded corporate equity securities, corporate debt securities, and municipal debt securities is the Depository Trust Company (DTC), and DTC's nominee is typically Seed & Company. Clearing corporations' books indicate that ownership interests of the brokers or banks that are its members, and the records of those intermediaries in turn indicate the ownership interests of their customers, that is, lower-tier intermediaries are at the bottom of the chain. The actual investors, people like yourself and I, for instance. An issuer defined in subsection 8.2.1 is the person responsible for the performance of the obligations represented by security. Usually the enterprise that places its name on the security certificate is an indication that the security certificate represents debt or equity of that enterprise. We can learn to issue our own securities by getting people in default via the private administrative procedure. We can get a certificate of default, then get it graded, securitized, and sold to a Series 7 broker at a discount. Article 8 provides that any person is entitled to complete a security certificate by filing in the blanks, other than those intended for signatures, as authorized and, in accordance with the general rule, a purchaser for value and without notice that a certificate has been incorrectly completed is entitled to enforce it as completed. This is what they do with anything and everything bearing our name, date, amount and signature on it that we have signed charged with their life force. This is why it is so important to learn how to control your notes, drafts, documents, and securities to ensure it can't be salvaged and used to enrich them. Issuers occasionally impose liens on the securities that they issue, for the purpose of securing payments owed to the issuer by the holder. An issuer's lien is not valid against a purchaser unless the lien is noted conspicuously on the security certificate. 8.209. An endorsement is simply a signature placed on a security certificate in registered form, or on an accompanying document such as a stock power, for purposes of transferring or redeeming the security. 8.102. 11. Medallion stamp. No endorsement of the security certificate by the transferor is required, and no physical transfer of possession of the certificate is required. Physical transfer is also not generally essential for legal transfer. As an allocation of risk mechanism, Persons endorsing security certificates are deemed to make certain warranties to purchasers, including warranties that the certificate is genuine, that the endorsement is effective, that the transfer does not violate any restrictions on transfer, and that there are no adverse claims to the security medallion stamp. Maxim: nemo dat quod non habet. No one gives what he does not have. An adverse claim is a claim that a person other than the purchaser has a property interest in the security and that is a violation of the claimant's rights for another person to hold, transfer, or otherwise deal with the security. 8102. 1. We have an adverse claim in our securities being traded in the markets. It is our property, and we have rights and interest in it. A protected purchaser is a purchaser who has given value, does not have to notice any adverse claim, and obtains control of the security. 8303. The indirect holding system is a pattern of security ownership and transfer in which investors, the ultimate beneficial owners of securities, have no direct relationship with the issuer. Instead, they hold entitlements to the securities through a securities intermediary. A security entitlement might be thought of by an lawyer as rights to a security that an investor holds indirectly, that is, through a broker or other intermediary rather than a direct relationship with the issuer. We have security entitlement. We are the entitlement holder to all security interests of the straw man due to our security agreement. A security entitlement is a bundle of property rights and contract rights resulting from an undertaking by a securities intermediary to prove an entitlement holder the rights that constitute a security or other financial asset. The entitlement holder acquires the security entitlement in most cases when the securities intermediary credits the financial asset to the entitlement holder's securities account. This is what we are seeking to do in liquidating the estate. Intermediaries' agreements with their entitlement holders are subject to the law of contracts, which brings into play policing doctrines such as fraud in the inducement and unconscionability. 1. 201. B. 3. 1. 103. B. Most municipal bonds and certain issues of commercial paper are issued in book entry-only form, meaning that direct ownership is not available to anyone other than a depository. These are the gatekeepers, the DDC, banks and brokers. Entitlement holders are protected from adverse claims to financial assets if they acquire their security entitlement for value and without notice of the adverse claim. The security agreement provides value and protects us from any adverse claims along with the UCC 1 filing. A security interest is an interest in personal property, which secures payment or performance of an obligation. 1. 201. 35. It gives its holder, the secured party, the right, in the event of default on the obligation secured, to exercise certain self-help remedies with respect to the collateral agreed upon with the debtor. C9, 102, 72, 12, 28. A security interest is said to be created, or to have attached, when it is enforceable between the secured party and the debtor. A security interest is said to be perfected when the secured party's claim to the collateral is protected against competing interests of third-party claimants through the debtor, including the debtor's trustee in bankruptcy. This is what we are doing with the security agreement and UCC 1 filing, etc. Investment property is a label for a type of collateral, distinguishing it from other Article 9 categories of collateral, such as goods, instruments, accounts, and so on, that Article 9 governs by other rules. The term is broad, covering all of Article 8's turf, securities, security entitlements, and securities accounts, as well as interest in commodity contracts and commodity accounts, which are not governed by Article 8 but are, insofar as interests are concerned, closely analogous to security entitlements and securities accounts, respectively. We have investment property. The first generally available means is to obtain a security agreement and give value, in the broad sense of 1-204, with respect to collateral in which the debtor has rights. 9. 203. B. 1. 2. The security agreement should expressly grant the security interest, describe the collateral, identify the obligation secured, and be authenticated by the debtor. 9. 102. 73. 9. 203. B. 3. A. All the debtor's assets, Although the security interest will be created by a properly drafted security agreement, it will remain unperfected, i.e., vulnerable to the claims of the debtor's other creditors and the trustee in a bankruptcy proceeding, unless it is perfected as described below. A creditor whose security interest is not automatically perfected will typically want to perfect it by taking additional appropriate steps, usually obtaining control or filing a financing state. Filing consists of the completion, and the filing with the appropriate public office, of a financing statement identifying the debtor and secured party and providing other relevant data, notably a statement indicating the types or describing the items of collateral 9/502, 9/516. B. Filing is usually carried out more or less contemporaneously with the executing of security agreements, because filing does not ordinarily create the security interest 9/308. One of Article 9's most important principles is that if the collateral is sold without the secured party's authorization, a security interest attaches to any identifiable proceeds of the collateral. 9/315. 2. When we become a secured party and have security interest in all of our debtor, strawman's, securities assets, we are entitled to the proceeds of any securities being traded without our consent. Article 9's most general priority principle is first in line, first in right. Article 9 provides that conflicting security interests rank according to the priority in time of either filing or perfection. 9/322. 1. 9/328. 7. The secured party has the following remedies for its borrower's default: to sue on the debt, or for any deficiency not covered by collateral, to enforce the security interest through judicial process, or, most important, to exercise self-help measures as to the collateral. Article 9 self-help measures include a zero making collections on collateral and taking control, in the vernacular sense, of its proceeds, e.g., dividends on equity securities or payments on debt securities. B. Taking possession of collateral, e.g., of security certificates. C. Selling or otherwise disposing of collateral to a third party. And D. Retaining collateral in full or partial satisfaction of the debt. Sometimes referred to as strict foreclosure. 9-607, 9-610, 9-620. Private administrative procedure. The United States Treasury issues securities through a commercial book entry system known as the Treasury Reserve Automated Debt Entry System, or TRADES. Nearly identical regulations maintain securities in the FRB's book entry system, such as the Government National Mortgage Association, known as Ginnie Mae, the Federal Home Loan Mortgage Corporation, known as Freddie Mac. Outside of TRADES, persons may also hold interests in Treasury securities through a system called Treasury Direct, in which beneficial owners maintain direct account relationships with the Treasury. Two relatively recent international developments are important to the law applicable to interests in securities held through intermediaries. The first, originally sponsored by the Hague Conference on Private International Law, addresses choices of law questions, and the second, sponsored by UNIDROIT, Internal Institute for the Unification of Private Law, addresses substantive law. The premise of both projects is that the rapid emergence of a global capital market in securities requires a new platform of legal rules that will serve the needs of participants in that market. This is what the UCC is a model for. For future developments on the UNIDROIT project, a good source of information is expected to be the International Law section of the UCC survey, published each August by the Business Lawyer.